Welcome back to the Two-Way Report. Remember that video we uploaded a couple of days ago where I talked about how Justice Amy Coney Barrett has thrown down the gauntlet and demanded Naperville, Illinois to justify their assault weapon and magazine ban? It was like she told them, speak up, Naperville, or face the consequences. It's a classic case of being caught between a rock and a hard place, and it's all part of the legal drama unfolding in the 7th Circuit, which has now reached the Supreme Court's doorstep. Well, the state of Illinois has finally submitted their reply to Justice Amy Coney Barrett and the Supreme Court on time regarding their assault weapons ban. But brace yourselves, folks, because the National Association of Gun Rights is challenging it in Naperville, and they've got some strong arguments to justify keeping their weapons. It's like deja vu all over again, as this is the latest craze in the woke left's efforts to infringe on our Second Amendment rights. Let's dive in and see what's cooking. So I'll show you what I think are the only important pages of Naperville's response to Justice Amy Coney Barrett. As usual, the link will be in the description if any of you would like to take a look, and I'll also rephrase all the legal mumbo-jumbo so you and I don't have to endure listening to lawyers speak in the next 8 minutes. So let's look at page 1, Introduction. This section confirms the state of Illinois has responded to a request by the National Association for Gun Rights, Robert C. Bevis, and Law Weapons Inc. These groups asked for an emergency injunction to stop a state law banning assault weapons and high-capacity magazines from being enforced while their appeal is pending in the Court of Appeals. The state of Illinois has argued that the law is valid and the injunction request should be denied. Naperville argues that the applicants, that is, the plaintiffs in this case, have not met the necessary requirements to show that the Supreme Court is likely to hear their appeal or that an injunction to stop the enforcement of the state law banning assault weapons and high-capacity magazines is necessary. Therefore, their application for an emergency injunction should be denied. Furthermore, Naperville also argues that the applicants have not proven that they will undoubtedly win their case that the state law violates the Second Amendment. The applicants also cannot prove that their claim that the state law banning assault weapons and high-capacity magazines violates the Second Amendment is valid. This is because the Supreme Court has not yet ruled on a similar case, and other courts have rejected similar challenges to similar laws. Therefore, it's not clear that the applicants will win their case. Additionally, the applicants have not shown that there is a pressing need for the Supreme Court to intervene right away. And lastly, Naperville asserts that the applicants didn't try to get an emergency injunction during the earlier stages of the legal proceedings, which makes it difficult for them to argue that they need emergency relief now. They are also relying on a legal presumption that the court has only applied to First Amendment cases, which does not guarantee the right to relief. Additionally, the applicants are using irrelevant tort cases and the financial losses of one gun store to show that they will face irreversible damage without an injunction, which is not convincing evidence. Now, let's fast forward a bit to page 6, where Naperville talks about why our friend's motion for preliminary injunction was denied. It says that on February 17th, the district court denied the applicant's request for an injunction. The court decided that the applicants are unlikely to win their case because the state law banning assault weapons and high-capacity magazines is consistent with the Second Amendment's text, history, and tradition. The court believes that dangerous weapons are not protected by the Second Amendment, and since assault weapons and high-capacity magazines are particularly dangerous, regulating them is within the state's power. The court also did not believe that the applicants would face irreparable harm because the gun store could still sell other types of guns and individuals could use other effective weapons for self-defense. Finally, the court determined that the state law and ordinance would protect public safety, which is essential. So, as you may have seen countless times before, this is some serious deja vu. The usual suspects are back at it trying to ban firearms by claiming that semi-automatic rifles are now dangerous and unusual. They want to lump them in with the NFA, despite the fact that Congress never included any semi-automatic rifle in the NFA definition, so legally speaking, they are not deemed dangerous and unusual. But as usual, these anti-gunners are spouting the same talking points, hoping to convince Justice Amy Coney Barrett, of all people, that ARs are too risky to own without extra taxes and scrutiny. It's like they're trying to pull the wool over her eyes and make her forget that she is a champion of the Second Amendment. Sorry, Naperville, but Justice Amy Coney Barrett is one of, if not the, strongest ally of the Second Amendment in communist America right now. It's time to stop fluffing around and admit that you lost. But hey, Naperville isn't done fluffing around and decided to talk about magazines. Towards the lower half of page 15, they argue that it's not a sure thing that the applicants will succeed in their argument that the restrictions on high-capacity magazines, also known as LCMs, violate the Second Amendment. This is because LCMs are accessories, not arms, and the term arms historically referred to weapons, not accessories like ammunition or ammunition containers. Well, it doesn't look like they've read about the Cayetano case. Or maybe they have, they're just hoping Justice Coney Barrett wouldn't make the connection. They argue that even during the founding era and the Reconstruction, cartridge cases and boxes were considered accoutrements, not arms. LCMs are similar to cartridge cases and boxes since they are containers that hold ammunition, so it's not clear if they count as arms under the Second Amendment. Therefore, it's debatable whether the restrictions on LCMs violate the Second Amendment and they might be considered accessories, not weapons. Naperville also contends that the applicants have not shown that high-capacity gun magazines or assault weapons are commonly used for self-defense, even if they are considered to be arms under the Second Amendment. They also say that the applicants used various sources to prove their point, but these sources do not provide enough evidence to support their claim. These only show how many guns and accessories are owned, sold, and manufactured for any lawful purpose, which is not the same as proving that they are commonly used for self-defense. They also argued that some of the sources that applicants rely on, such as an online survey, are unreliable and flawed. One example is the claim that 24 million Americans have owned AR-15 or similar rifles, which is contradicted by the government data that only 6.4 million gun owners possess assault weapons. They claim that the sources cited by the applicants do not provide evidence that the regulated weapons are commonly used for self-defense. Instead, they provide statistics on ownership and manufacturing, such as the Washington Post survey, which says that 6% of American adults own an AR-15 style rifle, or the Congressional Research Service study, which shows that 2.8 million AR or AK-type rifles were introduced into the U.S. civilian gun stock in 2020, or the Trade Survey, which states that AR platform rifles were nearly half of all rifles produced in 2018 and nearly 20% of all firearms sold in 2020. While these statistics suggest that the weapons are widely owned, they do not prove that they are commonly used for self-defense. Naperville also asserts that assault weapons and large-capacity magazines were originally created for military use and have features that make them particularly effective in combat. However, these same features are not typically used for personal self-defense situations. Assault weapons, for example, are designed to fire rounds at high speeds and with great accuracy over long distances, which is not necessary in most self-defense situations where the shooting occurs at close range. They follow it up with their expert opinion that assault weapons like AR-15s are not suitable for self-defense at home, as they can easily penetrate walls and cause harm to unintended targets. Moreover, their design features make them as effective as military-grade automatic weapons, like the M16, which is banned. AR-15 rifles are almost identical to M16s except for the automatic fire mode. These rifles are the most popular weapons regulated by the Act. And finally, Naperville reiterates that applicants failed to provide evidence that the Act restricts arms that are commonly owned by Americans, as only a small percentage of gun owners and an even smaller percentage of the American population possess the restricted weapons. Moreover, historical evidence shows that restrictions on weapons have been in place since early times, starting with restrictions on knives, pistols, and other melee weapons, culminating in bans on machine guns and other dangerous firearms. This historical tradition suggests that the Second Amendment permits categorical bans on certain types of arms. State and federal restrictions on firearms from the early 20th century, which are similar to the Act, are also permissible under the Second Amendment. Naperville, Illinois is proving that they're being run by stupid, tone-deaf, clueless idiots who know nothing about firearms. They're saying that large-capacity magazines and so-called assault weapons are not common for self-defense. They're accessories, and they're not protected by the Second Amendment. We'll see whether Justice Amy Coney Barrett will slap an injunction or not. I'm pretty sure she will. I'll let you know when I have an update. And that's all the time we have for today. If you want to protect your Second Amendment rights, please share this video with your friends, help us by subscribing and clicking on that like and the little notification bell too. Thanks for watching, and you have a good one.